Hello, my name is Dondra Meredith, and I'm here today as a representative of the Cabinet for Health and Family Services. Specifically, I'm in the Office of Legal Services. I'm one of the attorneys there. I'm the lead attorney on the new caregiver misconduct registry cases here in Kentucky. As you probably are aware, that law was passed, KRS 209032 was passed by the 2014 legislature and went into effect July 15th of 2014. Today I'm going to talk to you a little bit about the elder abuse and the warning signs, preventing elder abuse, and then what Adult Protective Services does when they receive reports of abuse, neglect, and exploitation. To tell you a little bit about myself, I spent 7.5 years as a prosecutor in the County Attorney's Office in Jefferson County. I've been at the Cabinet now about 3.5 years. In my time as a prosecutor, I spent about half of that time in adult guardianship in Jefferson County, so I was very familiar with the challenges facing our vulnerable adult population in Kentucky, and I'm very happy to be now working on the statewide level to protect vulnerable adults. I hope you'll enjoy this presentation today. As you know, our population is aging at a very fast rate. Approximately 10,000 baby boomers are turning 65 every day. This creates many challenges for their loved ones trying to find good care for them. As you're probably aware, there are many cases of abuse, neglect, and exploitation here in Kentucky. Those reports, unfortunately, are on the rise as we see that aging population rise. For every case of elder abuse, neglect, or exploitation that is reported, there are at least 23 cases that go unreported. So like with many crimes against the person, these are often personal crimes that just go unreported. But we do our best through your all's criminal prosecution efforts and through our efforts at the Cabinet now to hold the perpetrators accountable of these acts. One in 9 elder adults have experienced some form of abuse. That is a very high number when you stop to think about it. And again, we know those cases are on the rise, so that number is going to continue to grow. It's important that we spread the word, especially through the prosecutorial offices in our state. As our population is aging, we need to make sure we are addressing their needs and holding perpetrators of abuse, neglect, and exploitation accountable for those acts. And the latest data we have is the year 2014. In 2014, the Adult Protective Services Unit at the Cabinet for Health and Family Services received 29,350 calls to the hotline or through the internet. We also take web-based reports of abuse, neglect, and exploitation now. Out of those almost 24,000 calls, approximately 10,000 were accepted for investigation. As we'll talk about in a little bit more detail, not every call we receive is investigated. There has to be, we have to deem it a credible allegation before it's accepted for investigation. But again, about 10,000 cases that our social workers at the Cabinet investigated last year. Another statistic that you might be interested in is the number of names that we currently have identified on the new Kentucky Caregiver Misconduct Registry. As of November 2015, there are 51 names in that database on the registry. As we're going to talk about in a little bit more detail in a few minutes, that registry contains the names of perpetrators of abuse, neglect, and exploitation. Those are individuals who have been identified as perpetrators through an APS investigation. They've had the allegations of neglect, abuse, or exploitation substantiated against them through a social worker's investigation, and then they've been afforded their due process through an administrative appeals process at the Cabinet. So the 51 individuals identified currently on the registry have been identified through an APS investigation and have had their due process exhausted. All of those efforts have been exhausted at this point. We're going to focus on KRS Chapter 209 today. That's the chapter that contains all of the laws pertaining to the protection of vulnerable adults in Kentucky. Specifically, give you a little bit of background about the purpose of KRS 209. It specifically is laid out to provide for the protection of our vulnerable adult population. We'll get into the definition of exactly who that covers here in just a moment. But specifically, the purpose of these laws is to protect individuals who may be suffering from abuse, neglect, or exploitation, and to bring those cases under the purview of the circuit or district court. Now, obviously, in your roles as prosecutors, you play the role of holding perpetrators accountable. However, there are also, as we're going to talk about in more detail, there are also times where prosecution is not necessarily involved in cases because there are ex parte ways of getting protections for vulnerable adults, as well as the county attorneys, as you know, are responsible for presenting cases in guardianship court. So there are many different ways that vulnerable adults cases interact within the system, and we'll talk about those more specifically. Another specific purpose of KRS 209 is to make sure that everyone in Kentucky has the duty, the mandatory responsibility, to report suspected cases of abuse, neglect, and exploitation to the cabinet, specifically to the Adult Protective Services branch. And we'll talk about the specifics on how to do that in a little bit, but one of the important purposes of 209 is to make sure that all of us, every citizen in Kentucky, is held responsible for playing a role in the protection of our vulnerable population in holding them accountable for making reports of a suspected abuse, neglect, and exploitation. Another purpose is to promote the coordination of interactions between agencies that are designed to help and protect our vulnerable population. As you well know, that includes prosecutorial offices, it includes law enforcement agencies, it includes the cabinet. The cabinet mainly being in the social worker investigative functions, but as well as the Inspector General's office and other agencies within the cabinet as well. So with all of those agencies involved, it's important that we all work together to coordinate our efforts, and 209 ensures that we do that, which is one of the reasons that we're doing this presentation today for you. One of the things to point out is that KRS 209 specifically is designed to address vulnerable adults, and we're going to talk about specifically exactly who that population is in just a moment. But 209 does specifically exclude victims of domestic violence. As you know, you may well yourself handle those cases, but those are covered in a different area. Those are individuals. Victims of domestic violence can fall under the protections of 209 if they themselves qualify as a vulnerable adult or, under the law, an adult. As I've mentioned previously, KRS 209 is designed to protect the vulnerable adult population. Specifically, though, the law, the definition calls those individuals adults. The descriptor vulnerable is not included in the legal definition of who is covered by the protections of Chapter 209. However, as you can see from the definition itself, that term you can see where the term vulnerable adult comes from, because specifically the definition includes any person over the 18 or over who, because of their mental or physical dysfunctioning, is not capable of providing all of their own needs. It's those individuals who need assistance with activities of daily living or any other activity that you and I pretty much take for granted every day. Those individuals can include developmentally disabled individuals. Those can include our elderly population who, as they age, no longer can do those tasks for themselves. So it covers a wide range of ages and different levels of functioning. But pretty much anyone over the age of 18 who needs assistance is going to be covered by the protections under 209. KRS 209-0205 lays out specifically what protective services are required to be provided to our adult population, that vulnerable adult population. Those include investigations of possible abuse, neglect, or exploitation to determine if any action is needed. Now, those investigations currently in Kentucky are carried out through the Adult Protective Services agency through the Cabinet for Health and Family Services. I work directly with that agency at the Cabinet. Also included are any social services that an investigation might determine the individual adult needs to help either prevent or remedy a current ongoing situation of abuse, neglect, or exploitation. Another protective service is determining and seeking what any legal services that adult may require in order to remain protected. And again, as I mentioned, those can be prosecutorial actions, those can be protective actions such as adult guardianship court or other court remedies, which we're going to talk about in more detail in just a moment. I'm going to talk a little bit about kind of the social work side of what we look for when we're looking for one of the main things that's important to know for the population, since we're all mandatory reporters here in Kentucky. We all need to be aware of what the warning signs are for abuse, neglect, and exploitation. Right now I'm going to talk generally about just some general warning signs that would apply to all cases of abuse, neglect, or exploitation. One of the things that we have found is that many adults who are suffering from abuse, neglect, or exploitation, we see sudden withdrawals. These might be active individuals in the community, in their churches, in civic organizations, or other things. Perhaps they have a medical need, surgeries or things like that, and for the first time in their life they need care. Or it could be a developmentally disabled adult who suddenly becomes a victim. But you might see sudden changes in their behaviors. They may withdraw from their normal activities. That's a big warning sign. Also, when talking to adults who may be vulnerable, if they're looking, what our social workers find when they go out to do their investigations is one big red flag that they look for is if during the interview the alleged perpetrator insists on being present for the interview, and during that interview the vulnerable adult might seem hesitant to answer questions on their own, or they constantly look to the alleged perpetrator for the answers. Not being left alone to answer questions is a red flag. They might become isolated, or the perpetrator may be isolating them from friends or family that they had established relationships with in the past. They might be confined physically. They might just not be leaving their home anymore when they used to get out, quite frequently. You might see individuals who are suffering from abuse, neglect, or exploitation. When confronted about the problem, they might deny that anything is wrong, or they might minimize any actions that you point out. Especially, for example, you may ask about the caregiver's alleged abuse, neglect, or exploitation, and they'll minimize it. So that's something to look for. One of the things we look for when it comes to medical neglect is that the doctors, that they change doctors frequently, or they're missing appointments. Those are big clues. Another thing that we've found is that if individuals who've been fairly healthy start visiting their doctor or the emergency rooms frequently with just vague complaints, that's another indicator to consider. They also might provide implausible or inconsistent statements when confronted about, unusual bruises or unusual, activities that you might question them about. So that's another sign to look for. We're going to talk now about how the Kentucky law defines abuse. In Kentucky, abuse is defined under 209.020 Section 8. And that is the infliction of injury, sexual abuse, unreasonable confinement, intimidation, or punishment that results in physical pain or injury, including mental injury. Now, this is the same definition that is used in both your prosecutorial cases, the criminal cases, and in our administrative cases for the purposes of placing an individual on the registry. Again, the infliction of injury is very self-explanatory. That can be any injury at all. Sexual abuse, very self-explanatory. Unreasonable confinement, we've had situations where the improper use of restraints on psychiatric patients, elderly psychiatric patients, That has been a case that has come before us through the cabinet on the administrative level. It could be individuals at home who are receiving care that are being confined to their home and not being allowed to leave. It can be, you have to sometimes think creatively when we're talking about these laws, because some of them are not as clear-cut as others. Intimidation, that can take many forms. I've seen cases of transportation drivers where they've pinned individuals up against the van just for a few seconds, kind of shaking their finger at them. And we consider that on the administrative level intimidation. And then that punishment that results in physical pain or mental injury. Again, that can be any type of punishment, ranging from literally the spanking of a vulnerable adult. I've had cases like that. It can also just be, yelling at a vulnerable adult who responds clearly with an emotional distress of crying, or in one case we saw where an individual had reacted by just withdrawing suddenly. So again, that mental injury can take many different forms. Specific indicators of physical abuse that we should all be aware of are unusual bruises, black eyes, welts, lacerations, broken bones, sprains. Untreated injuries is another sign that there's ongoing abuse. Injuries that appear on the body in a patterned shape specifically, that's another red flag. Injuries in various degrees of healing. Some of these things may sound familiar if you prosecute domestic violence cases, because some of these are very similar to what you see with the victims of domestic violence, those abuse victims. Repeated or unexplainable injuries, one unusual injury in an adult who's having some coordination issues isn't necessarily a red flag, but continued different situations that are unusual or unexplained over time, those can be a red flag. And then again, injuries in atypical locations. That's another indicator that we all need to be looking for when we're dealing with our loved ones or just any individuals in the community. Indicators specifically of sexual abuse, infections in the genitals, pain or bleeding in the genital areas, unexplained STDs, foul odors or discharge. Sometimes you might get a victim who maybe they're not capable of any longer cognitively, or were never capable cognitively of telling you exactly the crime that's been perpetrated against them, but they might give you coded hints about what's going on, such as, he makes me do bad things, or I might be pregnant. Any sort of unusual comment that might be related to a sexual act. Those should not be taken lightly. Torn, stained, or bloody underclothing that can't be explained. And then again, the bruising in unusual places such as around the mouth, the pelvis, inner thighs, or in the genital areas. Those are all cause for concern if there's not a known reason for those injuries. Switching gears now to neglect, specifically caretaker neglect is what KRS 209 is designed to address. In the law, there are actually two types of neglect. There's self-neglect, and self-neglect is just when an individual, again, an adult as defined in 209, is not capable of meeting their own needs and they're neglecting themselves. And that's opposed to caretaker neglect, which we're going to talk specifically about today. That's obviously when a caretaker is responsible for providing the care needs of that individual, and that caretaker is not meeting those needs. Specifically, the law defines a caretaker for general neglect purposes as any individual or institution who's entrusted with the care of that adult. We're going to switch gears now and talk about neglect. Specifically, there are 5 types of neglect identified in the administrative regulation that the Cabinet promulgated for adult protective services. Those are hygiene neglect, supervision neglect, food neglect, environmental neglect, and medical neglect. Hygiene neglect is fairly self-explanatory. Those are the cases of neglect where the individuals are not toileted or bathed appropriately, and their person is dirty and unkempt. Supervision neglect involves neglect by a caretaker who is supposed to be with an individual and they are not present for whatever reason, and the individual vulnerable adult is not provided the level of supervision that they require to maintain their health and safety. Food neglect can be the deprivation of food. It can also be the provision of inappropriate foods, not enough food or spoiled foods. Our social workers see all kinds of different problems involving food neglect. Environmental neglect, that involves the environment where the vulnerable adult is either residing or cared for. Those can be problems such as mold infestations, improper sleeping arrangements. We've seen our workers have found vulnerable adults without beds or mattresses on floors. We've seen roach-infested, bed bug infested environments. Our social workers see a lot of ugly scenes out there involving environmental neglect. And the final type of neglect is medical neglect. That involves caretakers who do not seek emergency medical attention when needed, or they just miss appointments. They fail to make those appointments, or they miss them, and they don't seek any medical care. So that can take also several different forms. It can also involve either failure to provide medications as prescribed, either over-medicating or under-medicating. So there are many types of forms of medical neglect as well. Again, some specific indicators of neglect that everyone should be aware of. Dehydration and malnutrition, that can be sudden weight loss, bed sores, odors of feces or urine on the vulnerable adult, just general poor hygiene, again, that failure to seek medical treatment, inappropriate clothing for the weather, soiled linens or clothing, broken or missing medical equipment. Perhaps the individual wears prescription glasses, but they're not wearing them currently. Or maybe they need a cane and their cane broke and it's never been replaced. Any type of medical equipment needs that they have it should always be met as well. Again, we talk about that medication, failure to administer the medication properly. Dirty or unused kitchens or bathrooms, that's another indicator of neglect as well of the individual. We're going to talk a little bit about exploitation now. Specifically, the law defines exploitation as obtaining or using another person's resources by deception, intimidation, or similar means with the intent to deprive that individual of those resources. Now, on the criminal side of things, you as prosecutors know how important that intent is. One of the things that might not be so apparent when it comes to exploitation is what are resources? Immediately, what comes to mind, and I'm sure many of you have seen these types of cases, are when a caregiver exploits the individual financially. Maybe they steal a credit card and use it for their own benefit, or they steal checks and use it for their own benefit, or they steal expensive items from the home. Those are obvious cases of exploitation. One of the more unusual cases of exploitation that has come across my desk over the past year is we had a situation where a male nurse was asked by a supervisor to give a urine sample for a random drug screen at the facility as part of his employment. And he knew he wasn't going to pass that test, So he got really creative when his coworkers denied him their own urine sample to use on his own behalf. So he decided he was going to go into a male patient's room with a catheter kit and tell the individual that the doctor ordered a catheterization for a urine sample. This patient was lucid and remembered the incident. The male nurse just told him the doctor ordered the urine sample. The patient agreed. The urine sample was obtained. Luckily, the patient suffered no physical harm or mental injury, so it wasn't abuse. However, we decided on the administrative level, after much discussion amongst us attorneys at the cabinet, that was actually a case of exploitation, because our bodily parts, our bodily fluids, are resources, and he obtained that through deception, obviously, and used it for his own benefit. And so we've had some unusual cases of exploitation on the administrative side so far. So that's just one example of how sometimes you have to think outside the box when you're thinking about actions that are perpetrated on our vulnerable population. Again, some specific indicators of exploitation. One big indicator that our social workers talk about finding is when they speak with the vulnerable adults, they want to know, does the individual understand their own monthly income and the bills? Do they understand the cash flow situation? Do they understand what's coming in and going out? Oftentimes, if they do not have a good understanding of that, that obviously makes them very vulnerable to exploitation. So that can be kind of a first indicator. Missing documents. When those important documents go missing, perhaps your loved one had a will, and he or she can't find that will, and you're helping look for it, and you just can't find those important documents. That's an indicator that perhaps some exploitation is going on. Again, unpaid bills, that's a more obvious sign. Checks made out to cash. Unusual activity on accounts. Oftentimes, you probably have worked with law enforcement in situations where the banks, our financial institutions, are great partners when it comes to exploitation cases, because they often themselves call and make those reports to law enforcement and to adult protective services. Another big indicator is if you have an individual, an adult that has the resources to pay for a high level of care, but they're not receiving that care, that can be an indication that the money is going somewhere else that it shouldn't be going. And again, an individual caregiver who has received very expensive gifts. They might be in the form of cash. I had a case recently where I saw the caregiver who was actually employed by the care facility suddenly was receiving additional quote-unquote bonuses from the individuals themselves in the forms of cash payments of $10,000, $50,000. They started getting larger, so that's a big red flag. And then again, anytime you see the isolation of the adult, that's always a red flag that something in the form of abuse, neglect, or exploitation might be occurring. Anytime you're dealing with any of the forms of maltreatment of our vulnerable adult population, perpetrators can take many different forms. As with any criminal, there's no specific type of individual that perpetrates these crimes. However, what we have found are some indicators. It's oftentimes a relative. When those individuals are cared for in the home by relatives, those relatives have easy access to a potential victim. Caregivers in facilities also can be, unfortunately, are often the perpetrators of abuse, neglect, and exploitation as well. It's often the primary caregiver. As you can see, there are several indicators to look for when you're looking for who might perpetrate abuse, neglect, or exploitation. What are the effects of maltreatment on our vulnerable population? Specifically, I know this slide specifically says elder abuse victims, but these are for all of our vulnerable adult populations. They have a higher mortality rate, specifically up to 300% higher mortality rates. That can be as a direct result of the abuse or neglect oftentimes, or it can be more subtle in the forms of depression that leads just to complications to their health that ends up leading to their mortality. Obviously, these individuals suffer great distress, so that can lead to health problems as well. And just overall health problems, especially when we're dealing with neglect situations. If they're not getting those medical needs met, then they are going to decline quickly. As I mentioned previously, all individuals are responsible for mandatory reporting of suspected abuse, neglect, and exploitation cases. So what can all of us do if we see these signs that we've been talking about? The first and most important thing to do is to recognize the signs of abuse, neglect, or exploitation. We need to look for indicators of abuse and those behavioral changes. We need to ask about it. If we suspect it, we need to ask the possible victim and see if we can get more information about what might be going on. And then we have to report that to Adult Protective Services. In a little bit, I'm going to present a slide that has the specific hotline number. And there is also, I wanted to make you aware that there is a internet-based reporting format for non-emergency cases of abuse, neglect, and exploitation. And just, we need to remember not to dismiss the allegations just because they're coming from a vulnerable adult who may not have 100% cognitive capacity to understand the world around them. All allegations, even especially from our vulnerable adult population, need to be taken seriously. As I mentioned, Kentucky is a mandatory reporting state. Professionals as well as private citizens do have that obligation, as it is stated in 209030. And specifically, to point out, death of the victim does not relieve an individual of reporting that suspected abuse, neglect, or exploitation. And as I mentioned, how to make a report. There is the hotline that you can telephone in. That's 877-597-2331. That is manned 24/7. That is a shared line with child abuse or adult abuse. So it's a joint hotline for all cases of suspected abuse. As I mentioned previously, there is a web-based reporting system now, so you can go online and do that at the address there that's showing. Specifically, though, keep in mind that that is only monitored from 8 until 4:30, obviously during the business day. So if it's an emergency situation, you'll need to still call it into the hotline, because that, again, the telephone hotline is operated 24 hours a day, 7 days a week, and we can address those emergency situations immediately. Specifically, what does an investigation by an Adult Protective Services worker encompass? Well, the law lays out what specifically it shall be included in the investigation. That's in statute and regulation, as you can see on the screen. But to give you a little bit kind of how our investigators handle those cases, one of the first things they do is they make contact with the alleged victim. If the person is cognitively capable of giving an interview, then they interview that individual, but they always set eyes on the alleged victim, at least, even if the person isn't capable of participating in the process. One of the requirements of our Adult Protective Services investigators is to identify the perpetrator whenever possible. They've always had this role, but it's become I would say a bigger part of their work now since the Caregiver Misconduct Registry is in place, because administratively we are going to be holding those perpetrators accountable whenever possible. So that's a big part of their investigation. our workers do identify the perpetrator. They make every effort to contact the perpetrator, to interview them, to get their side of the story, because it is important when our workers are concluding on that standard of preponderance of evidence that they use, whether or not there is enough evidence for them to substantiate the allegation of abuse, neglect, or exploitation that they're investigating. The course of an APS investigation, sort of here in this flow chart, I've tried to simplify it as much as possible. But basically, a report comes into the hotline. We have Adult Protective Services workers that work the hotline only. They screen the call, the information given in that call, and they determine whether or not there is a credible allegation of the abuse, neglect, or exploitation of an adult. They check to see that all of the criteria for investigation are met. If so, they refer it for investigation. If it's not accepted for an investigation, that doesn't mean that we can't still offer some general services to a vulnerable adult who may need those services. So it may result in the offering of services. A worker may still initiate a case with the individual, but it may not be an investigation of a caretaker abuse, neglect, or exploitation situation. But if it is accepted for an actual investigation of maltreatment, there are guidelines that our workers have to meet. The first one is in any emergency situation where the vulnerable adult might be at risk, those cases must be initiated within 1 hour. Now, as you can imagine, that is a very quick turnaround, but obviously it's important because if there's an emergency situation, we need somebody setting eyes on that vulnerable adult as quickly as possible and addressing those needs and making sure that the individual is removed from any dangerous situation immediately as quickly as possible. One of the things that, if it's a non-emergency situation, they have 48 hours to initiate contact with the victim. One of the things that's done in either emergency or non-emergency situations is notifying the authorities notifying the authorized agencies within 24 hours. Authorized agencies are, as you can see, are specifically identified agencies. As we talked about, KRS 209 specifically encourages and mandates that all of the agencies who address vulnerable adults cooperate together. Therefore, notification to all those agencies is very important and must be done within 24 hours. The next thing, as I mentioned, the social worker is going to make a face-to-face visit with the vulnerable adult. They're going to assess that adult's cognitive capacity. They do that through many mental assessments. They have several different tools that they use to assess the individual's cognitive capacity. If they determine that the vulnerable adult is capable of self-determination, then they offer services to the individual. The individual may accept or decline those services. If the individual victim declines services at that point, really we have to close the case, because if the individual is cognitively capable of managing their self and their own affairs, then we can't do anything without their permission. If a competent adult wants services, then our social worker opens an ongoing case to ensure that any social services that adult might need are offered to them, and that individual can get whatever services they might choose to accept. Obviously, if the adult is assessed to be not competent to make decisions for themselves or to understand what's happening to them, then the social worker has to decide what actions need to be taken on behalf of that individual. There are sort of three main actions that our APS workers can take. They can, in the most emergency situations, they can take an ex parte request to a judge, a circuit court judge. That is an ex parte court order that allows a judge to issue, to basically act on behalf of the adult and issue the order for any protective services needed to immediately protect an individual whose health or welfare or resources are in immediate danger. Another avenue of help that our workers can offer is the involuntary hospitalization due to mental illness. Some of you may be already familiar with that process, called most often the mental inquest warrant process. That falls under the KRS 202A. So there's another part of the law that we can pull in as a resource for individuals who aren't competent. And then another avenue that involves court intervention for individuals is guardianship or conservatorship. If there is no, first of all, our workers, if an individual is suffering from abuse, neglect, or exploitation, they want to find loved ones who may be capable of providing services and protections to that individual. But unfortunately, many of our vulnerable adults don't have any loved ones that can step up and take that role. In those situations, we have to turn to the court, specifically the district court, and seeking guardianship for that individual. Now, guardianship, as you may or may not know, is one avenue legally where the loved one can take guardianship of an adult, or if there's no one available, friend, loved one, if there's no one capable or willing to serve as guardian, then the Cabinet for Health and Family Services, specifically through the Department of Aging and Independent Living, has guardianship caseworkers that can be appointed through the court system to serve on behalf of that adult. Once the worker is assured that the protective services are given, then the case is closed for purposes of the social work, adult protective services side of things. One of the things not mentioned in this slide specifically, which involves you all directly, obviously your offices are going to work very closely with Adult Protective Services in holding those perpetrators who are identified accountable criminally. I didn't specifically put that on this slide, but your office plays a big role in working with that coordination between agencies of holding those perpetrators accountable. One of the things that's important to understand that may come up in your work is that individuals who make reports of suspected abuse, neglect, and exploitation are given specific immunity under KRS 209. There's immunity for reporting as well as immunity for testifying in cases. Again, as long as there's a good faith report, a good faith testimony is given, those individuals are protected. As I've mentioned several times throughout today's presentation, one of the newest tools that we have in Kentucky in holding perpetrators accountable and keeping our vulnerable adult population safe is the Caregiver Misconduct Registry. That registry was created through KRS 209032 last year. It requires the Cabinet for Health and Family Services to maintain a registry specifically for employees and volunteers of vulnerable adult service providers and any other caregivers who receive compensation for their services who have a validated, substantiated finding of abuse, neglect, or exploitation. Those individuals are to be placed on the registry. The other requirement contained in 209032 is the requirement for vulnerable adult service providers in Kentucky to check the registry for all prospective employees. So any applicant must be screened to ensure that whether or not they appear on the registry. The law does also allow those vulnerable adult service provider employers to check that registry for current employees as often as they deem necessary. when the cabinet specifically goes out and talks to providers about using this registry for their benefit, we talk about using best practices for the registry, and we encourage those providers to check it for all current employees at least once a year. One of the ways we encourage them to do that is when they do their annual employee evaluations. We encourage them to go ahead and run a registry check on that employee at that time, because as you'll see in a few minutes, it can be a lengthy process between the time an individual is investigated and their name does appear on that registry. When the legislature passed the statute, it authorized the cabinet to promulgate regulations to fulfill its obligation, and we did that through 922 KAR 5120. One of the most important things contained in that regulation is that it dictates how long the placement on the registry will last. Individuals who have a substantiated finding of abuse, neglect, or exploitation that has been validated through the due process administrative hearing process, which we'll talk about in detail, those individuals are going to go on the registry for a minimum of 7 years. Now, this regulation does also allow a lifetime placement for perpetrators when there's a death or a near death of the vulnerable adult, and also if there is a civil judgment against the perpetrator or a criminal conviction against the perpetrator. Those, again, in those specific instances, there can be a lifetime placement on the registry. One of the things that the regulation does is that Adult Protective Services is now, when they conclude their investigations, they are required to notify the perpetrator of the findings prior to the registry taking effect. When an Adult Protective Services investigation was completed, there was no requirement that the perpetrator be notified of the findings. So oftentimes a substantiation was made against the individual and they were never even aware of it. And so, as you can see, if they weren't made aware of it, they certainly weren't offered a due process challenge. There was no due process challenge to any finding against them. So that's another big change that has occurred with the Adult Protective Services investigations. Now we must not only notify the alleged perpetrator, but we must also offer them due process to challenge the finding against them if they choose to do so. The burden of proof for the administrative side of holding these perpetrators accountable is preponderance of the evidence. As you all well know, we often call that the 51% standard. So we just have to tip that. Our evidence just has to tip the scale ever so slightly. And again, the same definitions that we've talked about previously of abuse, neglect, and exploitations are used in the registry law, so those are not different. Who can be a perpetrator under this law? The law specifically narrows down who can be placed on the registry. Those perpetrators can be employees of vulnerable adult service providers, volunteers of vulnerable adult service providers, or any other caregiver in any setting who is acting with the expectation of compensation. Specifically, when this law was passed, the lawmakers and the lobbyists did not want to specifically include family members who may be caring for loved ones. However, they didn't. The reasoning behind that was they didn't want to stigmatize family members who may be doing the best they can, but just because of lack of education or lack of financial resources, just weren't able to meet the needs of that loved one. However, they left the door open to holding those family members accountable if they are compensated. So any individual providing services for a vulnerable adult receiving compensation is eligible for placement on the registry. You might be wondering specifically, I've used the term a few times now, vulnerable adult service provider. Well, what does that mean? There are 12 types of vulnerable adult service providers listed in the statute, as you'll see in this slide and the next. Those are hospitals, those are group homes for mentally disabled individuals, those are assisted living communities, they are adult day providers, they are home health agencies. Again, there are 12 specific types of care providers. You've also heard me use the term validated, substantiated finding of abuse, neglect, or exploitation. As I mentioned before, previously, the result of an APS investigation was the substantiation or the unsubstantiation of the allegation. Now, not only does our worker substantiate or unsubstantiate an allegation at the closure of their investigation, but if we want to move forward with that subset of perpetrators and identify them for placement on the registry, we have to offer them due process, and we have to have that investigative finding upheld, or as the law defines it, we have to have it validated through the administrative hearing process. Specifically, what the law defines validated, substantiated finding as is a final order concluding by a preponderance of the evidence that the allegation of abuse, neglect, or exploitation did occur. We must also ensure that the individual alleged perpetrator has been afforded the due process rights offered through the administrative hearing process. Specifically, that must include an appeal right to circuit court, and as you'll see in just a moment, that is afforded to these individuals. The administrative case process differs, as you'll see, quite significantly in some ways and not in some ways from a criminal prosecution case. Specifically, the way it works with adult protective service cases involving maltreatment, those start with the investigation, which we've talked about before. That's when the APS worker does their investigation, and they, again, based on the evidence they gather, they conclude whether an alleged perpetrator has committed the offense of abuse, neglect, or exploitation. If they substantiate that allegation against the perpetrator, then it moves forward through the administrative process, even, as you well know, if it doesn't move forward through the criminal prosecution process. What happens at the cabinet internally, once the investigation is concluded, the report comes to the Office of Legal Services. That's my office. Currently, I am the attorney that reviews all of the case findings to ensure that the evidence, that there is enough legal evidence that I can use at the hearing to uphold that investigator's finding. If I find that there is enough evidence for me to go forward, then that case is referred to our cabinet's administrative hearings branch for a hearing, and that, again, that's that due process that we must afford these individual perpetrators. If I determine that there's not enough evidence to support a preponderance of the evidence finding, then I recommend changing the finding to unsubstantiated. That finding is then changed in the permanent records at the cabinet, and the individual is notified again that finding has been changed against them. We also notify all authorized agencies once again. Let me back up a step and explain. Authorized agencies are notified at the closure of the investigation. When we notify the perpetrator of the finding, we also notify the authorized agencies of the finding. So if we change that finding later, then for legal reasons, we also notify the perpetrator, of course, and we again notify those authorized agencies. If the case is referred for a hearing, it goes to the administrative hearings branch, where a hearing officer is assigned to hear the evidence. That case is then set for hearing, where the hearing officer hears the evidence presented by the cabinet and by the alleged perpetrator if he or she chooses to participate in the process. Currently, as you can see, the individual identified perpetrator does not even have to request a hearing or request their due process rights. Currently, we are automatically granting that hearing right because we believe currently that the interpretation of the law demands the hearing process in order to get what we call that final order before placement on the registry. So all cases are referred for hearing currently. Now, whether or not the perpetrator chooses to participate in that hearing is another matter. The majority, what we have found in the past year and a half, is that the majority of perpetrators do not participate in the process, which then eventually leads to a judgment against them. We do have some perpetrators who show up and want to plead their case, so to speak, and present their own evidence. Some of them have shown up with attorneys. Others choose to proceed pro se. I've seen pro se individuals have the finding changed against them, and I've seen individuals with attorneys have the finding upheld. So certainly we believe we offer the fairest due process that the administrative hearings process can afford an individual. After the hearing, the hearing officer makes a determination based on the evidence of whether there is a preponderance of evidence to find and uphold that investigative finding. They then issue a recommended order. The recommended order, again, is exactly as it's titled. It is a recommended decision about the case. Both parties have the right to file exceptions. That's the administrative term for appeals. Either party can file exceptions to the Cabinet Secretary because the Cabinet Secretary is the entity who makes the final decision and issues the final order in the case. When the Cabinet Secretary issues that final order, it is binding on the agency. So Adult Protective Services cannot appeal the Secretary's decision. That final order is binding on Adult Protective Services findings. If it's overturned, then again, that obviously would be overturned in the permanent records. However, if the Cabinet Secretary upholds the investigative finding against the perpetrator still has one level of due process rights, one level of appeal that he or she can seek, and that is to go to circuit court and ask a judge to review the Cabinet Secretary's final order, final decision. They have 30 days to do that from the time the final order is issued. Once the appeal time to circuit court has run, if the individual chooses not to appeal to circuit court, then they do go on the registry. As I mentioned previously, the administrative hearing process, the Department for Community-Based Services, specifically Adult Protective Services, we have the burden, again, that preponderance of the evidence burden, to show that the investigator had enough evidence to conclude that the perpetrator did commit the offense of abuse, neglect, or exploitation. We also have to prove that the perpetrator was an employee or volunteer of a vulnerable adult service provider, or that they were receiving compensation for those caregiving services. One of the benefits that we have on the administrative side that you as criminal prosecutors don't have in your prosecution cases is that hearsay is allowed in our administrative hearings. We can offer hearsay evidence, both in written and testimony form, but it cannot be the sole basis of any finding of fact. So we can offer it kind of to support the non-hearsay evidence we present, but it can't be the sole basis of a finding of fact. I've often received throughout the past year and a half, some of the questions I get from prosecutors that I've been able to speak to is, how does our administrative case affect their criminal prosecution? And I can tell you that usually it's not going to affect the criminal prosecution process at all. Specifically, what we have decided to do at the Cabinet is to, if criminal charges are pending, we are going to hold our administrative case process in abeyance until that criminal case is resolved. There are a couple of reasons for doing that. First of all, because you guys have a higher burden, if you all are able to get a criminal conviction through a plea agreement or through a trial, then that makes our case for us. We can use res judicata and get a summary judgment against the perpetrator in the the administrative case against them. The other reason that obviously that we've decided to hold these in abeyance and not go forward is that as a former prosecutor, I'm well aware of how important a criminal prosecution is, and we certainly don't want to do anything on the administrative side of things to jeopardize your evidence, your witnesses that you may need to prosecute your case. So we do make every effort to hold the case in abeyance. I have had at least one prosecutor come to me who was attempting to work out a plea agreement, and actually the administrative registry case was holding up his plea agreement, and so he asked us to go ahead and go forward with our case because he felt kind of the opposite of what I talked about previously is that if we win on the administrative side of things, he was going to get a plea agreement out of the defendant. So it can go both ways. Again, our office is more than happy to work with you in any way that you feel would be beneficial to you. If there's any way at all possible that you think we can help, please reach out to us. My name and contact information is at the end of this presentation. So please don't hesitate to contact us if we can help you in any way with your prosecutorial case. One of the things that you'll notice in the 209032 registry law is that placement on the registry is not automatic. It's not an automatic result of a criminal conviction. Many of us at the cabinet feel that that's somewhat of a loophole in this law. It requires us on both sides to go forward, whereas we would like to in the future see that loophole closed, but the lawmakers did not see fit to equate a criminal conviction with automatic placement on the registry. However, as I kind of explained previously, although it's not an automatic placement on the registry, we have been very successful in using the criminal prosecution against the individual in the administrative case. One of the things that we ask is that when you are prosecuting criminally for abuse, neglect, or exploitation, that you use proposed plea agreement language that we've developed here at the cabinet. It's just a tool that we ask you to use that will help us out on our side. It allows us to have a pre-existing agreement with that individual that they can go ahead and be placed on the registry as part of their criminal plea agreement. Specifically, that plea agreement language, as you can see here, is going to require your defendant to stipulate that there is a preponderance of evidence against them, and it does also require them to agree to basically automatic placement on the registry. Again, we would ask for your cooperation in using this language. Again, feel free to reach out to our office. I'll be glad to provide this agreement to you in a usable Word format if you prefer, or if you have any questions about it, please reach out. As we mentioned before, the law requires vulnerable adult service providers to search the registry for all prospective employees and allows them to check it for current employees. However, the registry law limits who can search that registry. Again, it's limited to vulnerable adult service providers, and individuals are also allowed to run a self-query or a self-check on themselves. So as you can see, that does limit things because even you as a prosecutor cannot access that database. I myself, as a cabinet attorney, cannot access that database because the law literally restricts it only to vulnerable adult service providers and individuals running a self-check. Now, many times when we talk about this part of the registry law, what we find is we get many questions from citizens and people out there in the community asking us, well, how can we use this registry to hire caregivers for our loved ones if we're not going through a vulnerable adult service provider? What if we just want to hire an individual through advertisement purposes? Well, certainly the registry can be used by individuals hiring caregivers outside of formal provider settings. The way we encourage citizens to use the registry is to have that caregiver applicant to run a self-query on themselves. That is a Social Security number based search, and I'm going to kind of walk you through how an individual, I'm going to walk you through it for a couple of purposes on how the registry search works, just so you'll have an idea of how it works, and then also if you yourself need it or a loved one needs it, if you have vulnerable adults in your family, or if you have just families of victims that might need to know about hiring caregivers going forward, you'll have a little bit more information to share with them about the actual registry search process. The first page you're going to come to when you visit the registry is this page, which requires you, it explains the law, it explains who can access the registry itself, and it's going to require you to identify or to affirm that you are one of those two types of entities or individuals that are allowed to access the database, either the vulnerable adult service provider or an individual doing a self-check. As you'll see here, I ran this on myself. That's how I came up with these. So I put in my own name. They require you to put in your address, and then you have to affirm that you are who you say you are. Again, that's obviously it's not foolproof, but at least we are trying to ensure that we are allowing people to access the database in accordance with the law and limiting that access in accordance with the law. When you go forward, you'll see that this is a Social Security number based system. As I mentioned, that's how we can ensure that individuals with similar names are not mistakenly placed on the registry. So we do base everything on their Social Security number. When you put in, it requires you to put in the Social Security number and confirm it before moving forward. And then it took I'd say less than 30 seconds before it came to this conclusion page. Again, I ran it on myself, so you can see there I'm not on the registry. But I blocked out, it does pop up, and it specifically says, no information is available for, and then it has the actual Social Security number. For obvious reasons, I've blocked out my own. And it says this search was performed on such and such, and it'll give you the date and the time that the result was given. And again, as you can see, this page can be either printed out or can be viewed in real time. And again, what we're telling people is if you use this for, if you have a caregiver do a self-check on themselves, either in front of you while you're conducting the interview, or if they can, if you choose to trust them to run it on themselves and bring you this printout, again, then individuals who are hiring caregivers outside of what I would deem, again, those professional service provider settings, they can still use the registry as a tool to screen out perpetrators of abuse, neglect, and exploitation. Is this a foolproof way to screen out those individuals? No. Unfortunately, there's no foolproof system to do that ever, unfortunately. But it is at least one tool that one additional tool we now have to screen out those individuals. The registry is a great starting point as a new tool to help us in Kentucky protect our vulnerable adults, but it has its limitations. You've probably already identified some of those as I've talked. One of the things that I'd like to point out that I probably should have pointed out earlier is sort of to explain why we have this registry law now. The impetus behind the law, the lawmakers found that vulnerable adult service providers wanted additional access to confidential APS records. Prior to this registry law taking effect, Adult Protective Services investigation records were confidential. The only way that employers had to screen employees was through a criminal records background check, which they would do. But as we all know, sometimes the criminal burden is so high that these perpetrators aren't prosecuted criminally. So what they would find is that an individual may not have a criminal background, but they might have had an Adult Protective Services finding against them. The only way prospective employers had access to those records prior to the registry was they could ask the applicant to fill out an open records request, basically consenting for the cabinet to release its records involving that individual. Now it's a much easier, as you can see, process. Rather than asking the individual to consent to giving the information, the vulnerable adult service provider can just jump on the website or submit a paper query. There is a process to do that, and quickly find out whether that individual had a finding of abuse, neglect, or exploitation in their past. As you can see, though, because of the lengthy due process rights afforded to these perpetrators, there could be a length of time, a period of time where there's an investigative finding against them, but it hasn't quite made it through the validation process, so their name is not yet on the registry. During that time, those individuals could still theoretically go down the street or to the next county and be employed as a caregiver at another employer, and their name not show up on the registry. So that is one limitation. But again, we do have to balance that with the due process rights that the individual has. One limitation, or what some people think of as a limitation, is that the placement only lasts 7 years rather than a lifetime placement for all perpetrators of abuse, neglect, and exploitation. As I mentioned earlier, the law does allow, through the regulation passed by the cabinet, lifetime placement for individuals who have been involved in the death or near fatality of an adult, or if they've had a criminal conviction against them or a civil judgment against them. So there are some opportunities for lifetime placement, but again, some people think that it doesn't go far enough, in that all individuals on the registry aren't lifetime placements. One glaring limitation of this law is that it does not prohibit employers from employing individuals whose names appear on the registry. In reality, what we find in talking to vulnerable adult service providers, although their main mission is the protection of vulnerable adults as they provide those caregiving services to them, they also factor in their liability. And certainly we know that's a hot button issue here in Kentucky over the last couple of legislative sessions, and probably will continue to be. But what we have found in talking to our vulnerable adult service providers is that although they're not prohibited from employing individuals on the registry, most of them have assured us that they have no intention of hiring anybody off that registry. I think we can all understand why that would be the case. So although it doesn't prohibit the hiring of these individuals, certainly it's going to significantly cut down on the numbers of individuals who have a finding against them, an investigative finding against them, from getting hired. As I mentioned, I encourage you to reach out to my office if you have any questions about any of the things that we've talked about today, especially if you have any questions about how the registry may or may not affect your case, or the plea agreement, or just any questions in general. Please feel free to reach out to my office. You have my contact information. As you can see, I've also included the contact information for Steve Fisher. Steve is the branch manager of the Adult Protection branch at the Cabinet. If you have any questions about the investigative process or the social services side of things that we've talked about today, I encourage you to reach out to Steve, and he's a great source of information more specifically about APS's role in protecting vulnerable adults. I thank you for your time and attention today.